It's the same for that.
It's 1 hour and a half. You can organize it beforehand. That way.
Yeah, I don't know.
Not so long. They're spreading
Oh,
the sleep. I do.
That's
So
me.
yeah.
And I was like, yes.
Come on in.
It's the lie on the thing. It was the girl that had them like, oh, that's perfect. Yes.
This is so good.
I know. For the pictures of Lee. Dallas.
Michelle, where do people, so people would see me on Zoom here. Oh, I see. Okay.
Yeah. Jeremy.
Yep, yeah, so any questions?
Oh, I see people.
Yeah, so this is how you move your, either that or that.
Oh, yeah. Okay. Okay. Yeah.
What's that?
Can you guys hear us online? Is everybody okay?
Yep, Juanita's. Okay, perfect.
Thank you.
Okay, Jeremy. Okay, we're recording, so we'll start.
I am.
There was so much.
Sorry. No, not at all. You're chilly.
Yeah, but.
Yeah. We're just, yeah, so thanks for having me again, Michelle, for organizing this. This is awesome. I love coming and being in front of you guys because it's so great to get FaceTime. I know that I email with lots of you about files and clients, and any questions and stuff. So it's awesome to, yeah, just put faces to names and get to know you better. And Michelle and I were kind of thinking about, I know there's like lots of different hot topics, things changing here. I think I'm coming back maybe in April or May to chat about the vacancy tax, which you guys are probably all like, yeah, that would be really helpful to know right now. But Michelle and I decided we would, I would chat with you about just, you know, what happens when you have a client who, you know, maybe has deceased and you're contacted by their family members to sell the home, or if you have a client that, you know, like somehow has become incapacitated and their power of attorney wants to sell the home. So just to, you know, I'll go through my slides, and like I have said before, I am like happy to make this, you know, not about the slides and more about questions that you have, so interrupt anytime. And otherwise I just use the slides to remind myself not to forget anything. And sorry, I am like, I've shared these slides with Michelle. So Michelle, feel free to send them out after the presentation if anybody wants them. And that's why I've put like so much information on the slides, is because it's just nice for you guys afterwards to just, yeah, so you don't have to take a ton of notes. So they're ugly slides, but it's just because I put stuff on there.
No judgment.
They're not the prettiest. Yeah, so the first part of the presentation, I'll just talk about, like, yes, what happens if you have a deceased seller, and then just the second part about when you have a power of attorney. But essentially, I wanted to kind of just bring to your attention how important it is to set up when you have a seller and they want to get into a listing, or their executor wants to, you know, to get the property listed right away. I just want to give you kind of like the things to think about and the questions to ask your clients, because it will, you know, save you time and maybe complication on the back end if you deal with this on the front end. So yeah, so I think first of all is just asking, you know, if you have a seller on title who has died, look at, of course, pull that title and see that they in fact are the only person on title. You know, if there is another person on title, it could be, you know, it could be a spouse that had already passed away a couple years ago, and then now the second spouse has passed away. So you have to sort of deal with both of them on title, and you have to, you know, often it will be in some sort of like joint tenancy, and really that person who passed away, it's their property to sell, but you do have to clean up that title. So get it in front of a lawyer right away to deal with the title. And then the other thing is just, don't be embarrassed to ask to see their will, the deceased will. Because one of the things, or at least if it's not you looking at the will, at least recommend that the executor who's claiming to be the executor and the right to deal with the estate, to tell them, hey, it's a really good idea to have the will read by a lawyer, provide you with advice, because executor powers are not all created equal. Some executors are able to deal with land, some executors are not able to deal with land. And also there could be a dispute about who the executor is. Like, often people will, and we don't love recommending this when we're doing people's wills, but some people want joint executors. So, joint executors have to make all decisions together. They cannot, like, one cannot instruct you over the other. You have to have like consent from both, or even 3 executors. So just make sure you understand whoever you're getting the instructions from is the correct person, and also that they actually have the right to instruct you, and whether or not there needs to be another person consenting. Yeah, sort of like I said, is there an executor named in the will? And does everybody, when I say executor, does everybody know what I'm talking about? There can be like either an executor. So when a person dies, if they have a will, they will have named a person in that will that they want to deal with their estate and distribute their estate, and that's the executor. If a person dies without a will, that's when you actually have to go to court and have the court appoint an administrator. So you could be dealing with an administrator, or you could be dealing with an executor. Both have, similar powers. If they've been granted the power to deal with land, both can deal with land. It's just a matter of one has been appointed by the court and the other one is set out in the will. And then of course, and you guys probably know this, from just experience, is, you want to ask the seller, okay, so this, the deceased has passed away. Has the executor been granted probate? Have they started the probate process? Because the probate process, as you all know, takes a while, and you want to like get in front of that before listing the house if you can. We always recommend, because anytime there's land that is not transferred to a joint tenant, so like if you have joint tenants on title, the land can automatically transfer to the surviving joint tenant. There doesn't have to be a probate application done. But anytime there's land and there's no joint tenant, if that land either needs to transfer to a beneficiary, or if that land is going to be sold, there has to be a probate application completed first, because that probate application is what names the executor as the executor, and then that executor can be put on title as the seller of the property. You can't transfer that property to any buyer until the executor is listed in the land titles office as the owner of the property.
God, there's a chair here.
Okay, just gonna crash.
Pull it around so you can see the TV.
Yeah, so just like those are the types of things to think about when you're asking yourself, who's my client and who can sign the listing agreement with me? You want to just make sure that you have that. And then just the question of like when to advise the client to list the property. Do you want to have all of these ducks in a row before you even list the property? Or from like, that would be ideal from a legal perspective, because then kind of, have that all out of the way. It's less complicated. You have the executor on title, probate has been granted. You know that the property can transfer. As soon as you get an offer from a buyer, you don't have an issue of like, when can we close and all that kind of stuff. So that'd be awesome. But I know like you guys are dealing with the public, and there's a lot of people who just want to get that property on the market because they're thinking, well, we might not even get an offer until a few months down the road, and we want to get this going. And they're thinking, jointly at the same time, we can list it and do probate at the same time, and hopefully it all works out. as you probably know, there's lots of times when the probate application takes a while. Like probate applications used to take a few weeks in the courthouse. Now they're a few months. They're taking 3 or 4 months just to get through the court system. And so those 3 or 4 months, that is before the application's even made. So when so kind of time wise, I would say what we see is when a person has passed away, usually, you know, there's you know, parts of the grieving process that are happening for a couple of weeks, and then we're consulted with, and the you know, executor will bring the estate to us and say, you know, what do we do here? We have some land, we have some bank accounts, you know, they'll hire us to look at the estate and figure out what needs to be done. And then we start collecting information for the probate application. So we have to collect and figure out all of the person's assets before we can even make an application, because what you do in a probate application is list all of the deceased assets that they have, bank accounts, savings accounts, you know, assets, you know, maybe overseas, maybe assets in another province, like all of these types of things. So we're searching for all that. So that sometimes will take weeks or even months. We're also looking at, you know, who are the beneficiaries, locating them, notifying people. That all takes time. And then by the time we get all of that grouped together in a package, we submit it to the court, and that's the probate application that goes into the court. Then the court takes a few months to process that application. And then we get a notification from the courthouse saying, you know, we're close to getting the probate grant, but now you have to pay some money, because there's a probate tax, so the whole value of their estate get taxed at 1.4%. So then we have to, you know, submit a check to the courthouse. Then once it's paid, then the courthouse says, okay, you know, stamp, this is your probate application. The executor now has the powers to transfer land and everything else. So we get that. Then once we receive that, we have to make an application to the land titles office to change the deceased names on title to the executor's name on title. That then takes a couple of weeks. So this whole process can take 6 months, 7 months. So I just want you to be aware of that when you're, you know, advising clients and they say, oh yeah, we want to list it right away. Just be careful, because then you're looking at a pretty particular buyer. That buyer has to be willing to wait to close for possibly multiple months.
I'll just take 1 second on the recording too, to just, I'll send out in the meeting notes with the recording, the board rules about having the probate application in your hands before you list, because executors, I think, are probably a little bit confused, because like you said, the application process, so they'll be like, oh yeah, we've been to the lawyers, we have our probate application. They might not know what they're talking about, so you need a copy of it. The brokerage needs a copy of it before activating the listing.
Oh, I did not know that.
It's a board rule.
Is that new? Because there's all sorts of houses that are listed
Without
probate.
Without the application? Just the application.
Okay, just the application.
Yes.
Okay, thank you.
Yes, I'll copy you on the rules.
Yeah, that's great. Thank you.
So there's something, and I might be getting ahead of your presentation here. Visually, we're sitting down with a seller.
Yeah.
And like what you just said on 1 or 2 pieces of paper, that like there's a line with deceased
like a
somebody.
timeline kind of thing?
So someone's passed away. Then it's
Yeah.
call a lawyer, speak to a lawyer about da-da-da.
Yeah.
And then it's this is 1 month or 2 months. This is application of probate. This is grant of probate. A cheat sheet, yeah.
That would be great. Please share that with me.
Not just for the sellers,
Great.
but for us too. And then where do we insert ourselves?
Oh,
on
as
that
the
timeline,
buyers, yeah.
Yeah, as the sellers representing someone.
Oh,
They
yeah.
come to me, like I have a listing, they want to list in April. And it's exactly what everything you've said. They're They've applied, I've just asked them to keep me posted on where are you at, and
Yeah,
but now I want to see the application, and so just something that would clean up a bit of a presentation when we're sitting down with somebody.
yeah, that's a great idea. Yeah,
Cheap.
yeah.
Yeah,
The
'cause
cheat
the other
sheet
thing
and
that we
timeline.
find too is it can be, like you were saying, you can be completed,
Yeah.
but not registered at land titles. That you can't close between those two, it has to be, have
Like
land title.
I had a deal that was like subjects removed and we were just like had to keep moving completion until it was registered at land title.
Yeah, yeah. Yeah, and we have, I'm sure you guys have in your bank of clauses as well, kind of like how to deal with that, because. You know, it comes up and you do want to have, you know, as the seller, subject to. You know, the probate application being complete and land title transfer to the executor completed, so that, you know, you're not, and you want that. You know, you have to insert that for every, you know, offer that you get, because you have to be protected, you have to be able to essentially push closing out until that happens, yeah.
I mean,
Yeah.
personally, and this is my personal opinion, I don't think it's in the seller's best interest to list it before probate is. Because as a buyer's agent, I'm totally gonna take advantage of that. And as a selling agent, you're not doing what's best for your client, once you can actually sell it, but you can't actually sell it.
Mm-hmm,
So once you can actually sell it, then you're actually doing what's in the best interest of your client.
mm-hmm,
And a
So-
pool of buyers who are buying.
Oh, yeah.
And.
And I take
can be
advantage of
like-
that all the time, like
Yeah.
that is, I personally, you know, I'm gonna say to a buyer, you are in a good position to buy this and take advantage of their situation, cause you can wait.
yeah,
Unless the market's different, like it was a few years back.
Yeah, for sure, yeah, absolutely, there's always factors,
Yeah.
but I just feel like on the seller side, even more so in a couple years back, it would be in your
When
best
the market
interest.
was going crazy and the sellers had,
Yeah.
they listed it and they could just blow it out, well, maybe a buyer's willing to wait the 8 months or whatever it takes to get to.
yeah,
So like on the cheat sheet, it would be, you know, here's your options. You could list now, but ... Your ideal time would be this ... Here's the risks with both.
yeah.
We haven't even got to contesting the will yet.
Yes, I know, I think I have that on a slide somewhere.
Right.
Also, something, Michelle, that would say, like, here's our lane as realtors, and here's what we can, and here's what we don't or can't. Here's a realtor's lane.
Can't is pretty.
When we look at like the Dort's version,
Right.
something as simple as possible as that,
It would be nice.
Yeah, perhaps, yeah.
just managing expectations and.
Yeah. The other thing, Sheridan, I wanted to ask about for estates and for POAs. When we get there is how you guys like it to appear on the CPS and the listing agreements. That's always my biggest question is, do we put the executor's name? Do we put the deceased name? What if there's two names on title still because somebody passed before, like how we want it written, but we can go over that.
Yeah, I do have a slide like that for POAs, but, and I can't remember if I do for executors too, but essentially I think you want. I'm gonna try to, yeah, exactly, I think I'll try to find it here, ideally, okay, best practice to match the LTO name on title, which is, sorry, naming sellers CPS. Best practice is to match the LTO name on title, and ideally this would be the name of the executor, so and so as executor of blah 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 estate, right? So that's if you actually have it, the executor registered on title though. I think that like, you know, what's your folks' experience when you're writing
Usually do estate
of
the person who is on title.
yeah, and because so even though I think you can still put the executor's name, because they are gonna look at, well, who's signing this, like this is like, who's this person, if this is the estate of so and so, who's John Smith, who's like signing for them. So I would still say, you know, so and so as executor of ABC estate, because even if you haven't received the probate grant, the grant of probate, they still are acting as executor. They just are not They just don't have like the court stamp, and it does, and LTO will not transfer the land, but they're still the executor, like they're still making decisions, especially once they've gone to the lawyer, the lawyer has read the will and said, yes, I will take instructions from you, you're clearly the executor. Here, so I think it's safe to do that.
So you could, so almost have both, so estate of
You would
John
have
Smith,
both their names.
executor, executrix,
Exactly,
Tracy Gobel.
so I would put, exactly, I would put.
Michelle Gerard as executor. Or Michelle Gerard
Exactly.
as POA.
So you actually
You have
have
both
the,
names.
yeah, so you have you have the
Just
executor,
clarity.
yeah. You have the
Yeah.
executor or POA's name and the name of the person they're representing. Yeah,
That makes sense.
I'm just gonna try to go back here, but I think we're.
Yeah.
I think I was kind of jumping all over, so I think we kind of went through most of this stuff, the like, what is probate? When it can occur, when the sale can occur. Yeah, so we've kind of covered all that stuff. I think we've covered timeline for probate too. Yeah, and
Yeah,
both.
there's your cheat, there's part of your cheat sheet anyways, copy of death certificate, about the lawyer,
Yeah,
application started. Timeline.
yeah, and I guess I should point out here too, so if there is like a huge rush in selling this, there is an emergency application that you can make it into court, that the seller can make into court. So that they don't have to wait through the regular probate process. But it's really at the discretion of the judge as to whether they will allow this sort of emergency application to go through. And I'm sorry, I haven't done one, so I don't know exactly what the test is of what an emergency would be. But if you have a client who just says like, I can't wait 6 months, again, tell them to see a lawyer. The lawyer will look into what what's the test for an emergency and whether that could be a step for them they want to take, but of course it'd be a way more expensive process because you'd have to prepare the application, go to court for it and all that kind of stuff, probably like 5 to 10 grand. And yeah, like Jamie was saying, and you guys were saying, we as lawyers recommend waiting until the probate application has been granted before listing it. Maybe might make life simpler. Yeah, so then, and we did talk about like kind of the administrator instead of an executor. So an administrator is who gets named by the court as administrating the estate if the person has died without a will. And usually this will be like a family member, a friend who steps up and says, okay, well, I'll administer the estate.
And in that case, on the CPS, we can still use the verbiage executor for the estate.
I would say
The
administrator.
administrator.
Yeah.
Okay.
Yeah. Yeah. And I would again just place even more emphasis on the time, because the administrator can be contested. What if there's more than one child who wants to be administrator or something like that? Like, I would say, let's wait until, and really you're like the executor and having the lawyer's opinion that the will is, to the letter of law, and you have an executor in place and you guys can say, okay, I know who my client is and I know who I can take instructions from. If somebody's just acting as administrator before they actually have the court order, I'd be a little bit more weary about, signing a listing agreement with them and taking instructions and stuff.
Is there any like family hierarchy that plays in
Yeah.
administrative, like is it a direct heir?
Yeah, there is, and I'm sorry, I don't know off the top of my head, but there are sort of like in law, the recommended folks who are going to be, like, if they're putting their name forward, it's going to be, more weight than say a friend or something like that. Yeah, a blood relation for sure, like a direct child, sibling, parent, something like that, yeah. Yeah, and just like I said, like, the executors, you have to get them all into a consensus if there's more than one. Same with administrators, there can be more than one administrator. People can apply for joint administration, and then again, you need to have consent from both. And then if the deceased seller has a spouse, most of the time, as you probably know, most of the time, you know, spouses in a more traditional marriage will be on title as joint tenants. So you don't really have to worry about the transfer of the land, because when one spouse dies, they just, you know, hire a lawyer and then they transfer that title to the property automatically to the surviving spouse. Where we have seen like a lot of issues, there's so many, and I'm sure you folks are seeing this too. There's just so many blended families now. And there's so many second marriages, and there's you know, so much of that that you will see, you know, a piece of property with, let's say, you know, the deceased woman's name, she's the only person on title. The kids say, okay, we're, you know, here's the will, she named us as executors, we'd like to put the house up for sale. And nobody mentions that, in fact, there's a spouse that has been living in that property, not on title, and the spouse has a spousal family law right to the property. And so again, you have to be careful, of course, for timing. So this is a good question to just like ask and present to your clients. Is there a spouse? And even if, and this is like typical of law, there's gray areas about who is a common law spouse, right? So, you know, again, black and white version is, have they been living in a marriage-like relationship for 2 years? But the law has a lot of gray area with that. It's like, what is a marriage-like relationship? What if they've had two separate homes, but he sleeps over 5 days a week? What if they have, right, like blended bank accounts? What if, you know, he's helping her pay for some of the mortgage, whatever? There can be a lot of dispute about what is a spousal home. And so if there is a spouse, again, send everybody for legal advice if this comes up, of what is a spouse. But if there is determined to be a spouse of the deceased, then the executor can't list the property for 180 days from the date of death, because there's a spousal claim that might be made on the property, and this lengthens the probate application time. So unless you can get, I've had it before where you know, my clients are the kids of the deceased, and there was a male spouse, and we all so it was a very amicable situation, and the spouse said, don't worry, I will consent to them selling before the 180 days. That's no problem. He didn't want any claim on the house. He wanted the kids to have it. That's like what he wanted. So you can get consent as long as that's amicable. But if the spouse is not willing to consent, then you have to wait that 180 days. Yeah, and there also could be provisions in the will about giving the spouse a right to live in the home for a certain amount of time, or a life estate. You know, you folks have probably seen life estates on the title of the property. There are also, so if it's there, you know, there's such thing as a registered life estate in land titles office. That's pretty clear. You're not going to be able to transfer a home if there's a registered life estate for a spouse on there, or even for a, you know, child or something like that. But there is also unregistered life estates. So it may not be in the land titles office. It may be within the will, or even just like as an auxiliary document to the will, there are life estates. So again, just try to flush that out as much as you can. Yeah, and I think does anybody have any questions about that? It's kind of a tricky area, especially as we see it more and more with blended families. So yeah, like I said, so it's kind of a couple of scenarios. Either the deceased may leave the spouse some right to the house in their will or through a life estate, or even if they're not provided for a right to the house in the will, the spouse will still have a right under family law for that house.
So the question regarding that, if there is a mortgage on property,
And the mortgage is in the deceased person's name, but there is a provision in the will for a life estate. What happens under that mortgage? Does the lender not still have the option to say, no, you have to sell to clear out the mortgage? So the life estate is basically, like, what happens in that situation?
Yeah, it really depends, and this is why proper estate planning is so important, because like the estate might actually have to pay out that mortgage,
Okay,
right? Because it's a liability of that estate, so it may be, and that's where people, so say this deceased, should have seen somebody to do their estate planning. If they wanna leave a life estate to the wife and they're leaving a whole mortgage debt for their kids, and the kids essentially get nothing, and they're waiting just for the wife to finally leave the house until they can get that house, it's pretty crappy. We try to get people to do the planning early on in life so they can get life insurance to pay out that mortgage, because by the time, if you're really old, you're not gonna be able to afford that life insurance for the mortgage. But that's essentially what we're trying to do with blended families is, make sure you have life insurance in place, either to pay out your mortgage, or if you're leaving your house to your new spouse, then life insurance to your to your kids from a previous marriage, so that everybody isn't fighting.
Yeah.
And everybody kind of gets peace, and that's not just, every situation's a bit different, but that's kind of one way to deal with it. But yes.
Just on the 180 days, if they've begun the application for probate,
Mhm.
and that's moving along within the 180 days, can we go ahead and list the property? We've got probate granted, the title's been transferred. Can we go ahead and list the property and then the spouse put in a claim? If they were within the 180 days,
They
or,
might
If they-
not
yeah,
have
if they-
to wait until that 180 days is done, right?
well, that's 6 months.
Yeah, no, that's you have to, before the property is transferred. Yes, like like you said, so if they get probate really quickly and you're selling the house and they have a grant of probate, there is a time when a spouse can still make a claim. So we have documents that we. Yeah, we have documents that require, so anytime we're acting for a buyer, we send documents to the seller side, and the executor has to swear a statutory declaration that there's either no spouse, or that the 180 days has passed, or that the spouse has consented.
Gotcha.
Yeah, so we won't transfer without that, and that's kind of like.
So that would kind of suck.
Yes, yeah.
That's on you, not.
But that's why seeing, that's the acting for the buyer side, we have that interest that in mind, that we have to ensure is clear. But like as the seller side, that's why you just want to be like super clear as a seller, like, is there a spouse? Should we wait the 180 days? Cause you don't want to enter into an agreement, be in breach of the agreement, because all of a sudden you didn't do the spousal check and the spouse is now making a claim. Right? Yeah. Yeah, and this is, I'm sure there's lots of you who have done early possession agreements for folks, so you can do as much advising and planning as you can with clients, but some clients are just like, no, we want to get this thing sold, and we want to accept this offer, and we want to let the buyer into the house early, and all this good stuff. And so, whenever that comes up, please feel free, and I'm sure you guys have like a good bank of standard clauses to deal with possession agreements, early possession agreements, but just make sure that you have your advice from your broker on how to draft those possession agreement clauses, because and also I would suggest having an agreement in the CPS. Do I suggest this? Yes, I think so. I think that you guys want to do is probably have a clause in there that says, subject to the buyer and the seller entering into a separate possession agreement, because we have lots of possession agreements, right?
Yes, don't draft them.
We just go.
Yes.
Go to the lawyer.
That's what I was
Put a
like, I
condition
think
for
this is
Sheridan.
yeah, because they're tricky, because I've had lots, like we probably do 5 a year or something, like just me alone, just and there's always little differences in each of them, like sometimes sellers want rent for when the buyer is in there, sometimes they negotiate no rent to be paid during the month. There's always like liability issues, you wanna make sure like, and then you wanna make sure that the seller continues to have insurance for the whole time, and like just all of these little things to make sure that that happens. And I would say like we advise people not to enter into these because we don't love the idea of the buyer getting into the property before it's actually sold. You know, what if they're not happy with it? What if there's, you know, things that break down, and there's like obviously so much risk of like conflict and stuff. But I would say like all of the possession agreements that I've drafted, there's some hiccups, but they have all turned out. You know, so it can happen, but yeah.
Going
so-
forward for CBA.
Yeah, okay.
Lending, like one of the things that I worry about, I've never come across it, but like. Sometimes buyers don't realize like, oh, your mortgage rate is only good for 180 days.
That's a great point,
And it's
yes,
like,
yes. Yeah, that is such a good point. Mhm. Yeah, and everybody knows what Jamie's talking about, right? Like you have a buyer who's been approved for 180 days, and then because of the probate taking so long, by the time the closing date actually happens, they no longer have approval on their mortgage, and they have to reapply, and then the crazy thing is arguing like this buyer would be in breach if they can't
totally,
close. We have, like, I have tried to put clauses in the possession agreement to say that the buyer can back out if
Oh.
the financing doesn't go through, but usually that gets struck out by the seller. But like we have tried to like kind of put protections in there, and maybe you could negotiate that with the seller, that like, you know, because the seller is kind of in the wrong in putting it in the market before,
totally.
yeah, before probate.
Yeah, but yeah, and true, same thing, right? First majority.
I guess this is like one thing that sometimes what happens is the seller will enter into a CPS, and before the closing date, the seller dies. So technically the seller doesn't have a subject to like if you die. So you're kind of at the mercy then of the buyer, and you're saying, well, we'll let you in early until we get probate. But again, that's like gotta be kind of negotiated. But it does become a sticky situation when the seller dies between signing the CPS and yeah, and we've had that before, and again, like if you ever have any sellers that are kind of like really elderly or like lots of issues, try to get them in for signing like right away. Because we can actually, well, and the crazy thing is if we have the signature from the seller while they, go ahead, Jeremy. If we have the signature from the seller on the transfer document, even if the seller has died, we can submit it to land titles and they will transfer it. So, like, that's why we wanna get them in to sign.
I know. She visited the patient in the seller in the hospital.
Yeah,
Like, to get them to sign, it's like above and beyond, right?
yeah, I think we had that last week,
Yeah.
one of our lawyers did that.
Yes.
Yes. Yeah, so this is just that naming that seller in the CPS. Like we said, you wanna name both the seller and the deceased and the executor. I just see that I missed a message here. So what is the process if a property is listed under a POA and the legal owner passes away before an offer deal is completed? Well, we just went over that. Oh, I guess, okay, so this is just a slightly different. So if the property is listed under a POA and the owner passes away before the deal is completed, then we have to go into probate because the POA cannot sign the transfer document because they're no longer, the POA no longer is applicable because they're dead. The person has to be alive for the POA
Right.
to work.
Yeah.
Yeah,
And the deceased, you know, signed early, there was a reason.
Yeah. So that's a really great question. And again, like if you, like, we do have people who say, well, what's better? Should we have the POA sign or should we have the seller sign? And I always say, well, have the seller sign because and we'll get all of the transfer documents signed by the seller so that we can transfer if they pass away, because if the POA signs, then it's basically moot if the if the seller hasn't signed the transfer doc. So, does that make sense? Yeah, okay.
Recommend legal advice.
Yeah.
Yes, I know.
And get everything's older.
Yeah.
Yeah, there's a reason I'm here, hey, like just championing. Come to me.
Yes.
Yeah. Yeah, okay, so then this is just the POA portion of the presentation too. So there's, just so you guys know, if you didn't already know, there's different types of powers of attorney. They're not all made equal. So again, just like a will, if you have somebody who wants to sign as a power of attorney for your client, then have them take the power of attorney document to a lawyer and get legal advice to ensure that they can instruct you and they can deal with land, because not all powers of attorney allows the attorney to deal with land. And also there are like a general power of attorney. It expires 3 years after it's made for land purposes. So most people don't get a general, but some people do, just because they're like, oh, for this short period of time, maybe I'm out of the country or something, I want this 3-year power of attorney granted to somebody. And then it expires, so you have to watch for that. And then there's springing power of attorneys, so that's actually triggered by a certain event or a time frame. Sometimes that means that the triggering event is actually incapacity. So some people will only grant a power of attorney that comes into effect if a doctor has said you don't have capacity. So then if that's the case of that power of attorney, everybody, including the lawyers and everything, want to see, okay, let's see evidence of the triggering event. We need a doctor's, confirmation and like that kind of stuff. And then like a typical power of attorney that we will draft is a power of attorney that is useful in any case. So it can deal with land. You can use it if you are incapacitated or not. You can use it, once they're capacitated, or even if it's just for your spouse, if they're traveling, they can use it. So anyways, get just advice on the power of attorney document. Like we said, it should be registered in the LTO. It's nice if it's registered in the LTO before you even list, because then it's on the land title, it's on the title, no buyer will be confused who this power of attorney is. And again, there can be multiple power of attorneys, so if you have like a joint POA where people have to act jointly, you have to have both the POA's consent. And again, we don't usually recommend that because lots of times, maybe siblings won't agree, or one's in Alberta, one's in BC, like that kind of stuff. So, we try to make it so it's just like one person as the POA.
Just a quick question about the POA. What should you do, or what are the consequences if maybe you suspect that a POA is not acting in their best interest?
Yeah. I have had a realtor actually ask me about that.
Sure you have.
Yeah, and there is like the parent, guardian, and trustee of BC, it's a government body that oversees situations where people are incapacitated and they need like a committeeship or like a trustee or something like that. So you can I think there's probably like a complaints website, or I didn't go down the whole road with her, but the realtor, I sort of directed her in that direction. But I think that's very much it's going to become more and more of a big deal. So I should probably get an actual direct line that you guys should call, and somebody that you can contact, because we are our the Law Society is just basically putting it down our throat that there's so much undue influence that's happening as our population ages. There's like, you know, a ton of like even fraud and stuff within families and everything. So yeah, it's a really good question.
Did you see that too, unfortunately?
Yeah, I
did see
bet.
that.
Yeah,
Something.
yeah, and if you can kind of like try and you know, like collect as much information you can about a relationship too, if you think that that's happening, because we see people so like quickly, just like an hour of a signing appointment or something, and we're supposed to like judge legally whether or not a person is being unduly influenced. I think it's so much, like, I think it's so important that if we can contact somebody like you guys who have had a long-term relationship with the clients and say like, what's going on here? Like, it seems weird. Why is the, you know, daughter or the son like in every appointment and basically signing for them and like stuff like that? Yeah. Yeah. And we just got like the lawyer insurance fund that insures us, our professional insurance, just put out a big long article about how it's like the cases against lawyers missing undue influence and being sued for it has like doubled in the last 5 years. Like, it's, yeah, super scary. Yeah, and then okay, so this is just like brings up this conflict of interest, right? So the attorney cannot pay themselves, they can't benefit from any transaction. They really they can't sell the property to themselves. They can't use any information they receive as a power of attorney for their own benefit. They can't tell a friend about an upcoming sale and sell it to their friend. They yeah, they can't give themselves any commission, like, you know, try to split commission with you guys. You know, they can obtain assistance on matters, so like they can hire you folks, they can hire us. They, you know, and they do that to protect themselves, because we have a duty as lawyers and realtors to, you know, try to determine whether there's any undue influence. So they sort of protect themselves in that way. So we have to make sure that, you know, that they're not using us in that way to make it look like it's legitimate when really it's not. Yeah, and there's so there are like the person who granted the power of attorney, so essentially the person who's, you know, signed the power of attorney and gave it to somebody else, gave it to their power of attorney, they can cancel a power of attorney, and there's no way that to know whether it's been canceled. Like, there's no registration for POAs. So you should ask the POA directly if it's been canceled, and shift that liability to them, so that they would have to, you know, be lying to you. It's essentially like the foreign buyer ban stuff, right? Like, we have obligations to ask, are you a foreign buyer? Do you have, you know, working permit in Canada, that kind of stuff. And as long as you've asked the questions and done your due diligence, then you're, you know, you're good most of the time. Yeah, I mean, if you can talk to both the power of attorney and the grantor, if the grantor has any capacity, that's great. To see that they're all on board, that's even better. Have them in the same room. Yeah, so if a POA goes into bankruptcy or a grantor, then they will be replaced by a bankruptcy trustee. That's pretty like far-fetched, but oh, there we go. Here we go. Public guardian and trustee, if they receive a complaint, they can take over as POA. So yeah, so there is somewhere contact information that they can take over. And if there's any indication that the public guardianship has invoked their role, you must work with that public guardian and trustee and no longer work with the POA. And that's when a commentee is court appointed, and then they handle the person's affairs. And like, we just went to court and got a commentee for somebody this week. So yeah, it's just becoming such a big area of the law. Yeah, so if you're acting for if you're acting for a buyer and there's like on the CPS, somebody has signed as a POA or executor, but you don't see it on title. I would just say put this clause into your buyer's contract to protect them and say, it can either be subject to the buyer's lawyer reviewing the seller's POA on or before such and such date, or just subject to legal advice could cover this, and you would just want your client to go to the lawyer, their lawyer, and say, what should I be asking for? What should I be looking for? I want to make sure that we're like entering into the contract with the right person.
Yeah, I think as listing agents, it's a good out to say to your clients, like, POAs are all different. Can you hook me up with the lawyer so that we can together make sure that it's the right.
That you have the
type of
authority.
POA that you have.
Yeah, and that's it. Yeah, it's just a chat here.
Here in the office, don't we want the power of attorney paperwork on file?
Yes.
Other than
It's a
yeah.
it's a requirement, isn't it?
Yeah, like, but the desk doesn't read it to make.
Yeah,
sure
totally.
that it's a POA.
Yeah,
So.
totally. Thankfully, it says enduring usually, which
Yeah.
is a good start.
Yeah.
Layout, if it applies to land or not.
So that.
Yeah, it does say
It
that.
does state, yeah, it's like, it's not actually a really legal easy kind of a.
No, like a
Document.
one page, right? Yeah.
It's quite-
Mhm.
quite-
It's true, unlike the health rep agreements that are like
Right.
15 pages long, yeah.
Yeah, it's definitely cute. Right there, got it.
And the banks, because they have to deal with it all the time too. And I just see Bonita has said that I had a situation where the principal had appointed 3 powers of attorney and they could all act independently from each other. What do you recommend when the property is involved?
Recording the state.
How to bring that, yeah. Yeah, I mean, I would definitely try to get them all on board anyways. Like, I would just say like, hey, maybe can we just like.
Strategy.
Yeah, it's a good strategy just to get them all, if you can get in writing from all of them in an email that like, hey, we're gonna list the property, like, is everybody good with that? That'd be great. That's like best case scenario. But if they can act independently, again, I would get a lawyer's legal advice to say like, can we enter into these contract with just this one?
Through lawyers.
Yeah, potentially.
I've done it with 2.
Oh,
They didn't
yeah.
agree, the kids didn't agree.
Yeah.
And we ended up, and all the way through, they didn't agree on anything, they didn't agree on the price.
Like that.
The buyers had to, like, it was just a nice.
The seller is
I paid for me and the 2 lawyers.
Yeah, communicating through everything, and you finally got it sold. Yeah, do you even want that? Maybe refer it out, yeah.
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 I was gonna say the tiers, it's just not good.
No, and that's why we just keep pushing people to try to do one POA, one executor,
Yeah.
like, unfortunately, pick a favorite child.
There's key.
Yeah, no, exactly. Yeah.
Any questions for Sheridan?
Mhm. I know I've thrown like so much info at you guys.
It's useful, though.
And then I guess like follow-up questions, because you're so generous with your time. Ski stuff. I'll just have these guys filter questions through me.
Yeah, that'd be awesome. Yeah, for sure.
Yes, yeah, and a recording.
Oh, yeah, and yeah, feel free to share the slides or whatever. Yeah. Hey, awesome.
Finish on time and everything. So great. Thanks, Zoom people.
I know.
Thank you.
Thanks.